remember getting out of work. I remember standing by my bike. It was still light out, but the sun was going down, and then I took off down the road, and that's really the last I remember.
The doctor said, your husband is broken from head to toe. We can't get the bleeding to stop. I've been inside him up to my elbows, trying to do as much as possible.
How does your breathing feel right now with the speaking valve on?
It's okay.
It's okay? Does it feel harder to breathe with it on?
Yeah, it's not hard.
Yeah, that's normal.
I don't remember the exact time that I actually realized that I was in a motorcycle accident and then I was in a hospital. We have a friend who is an attorney. His name is John Adams, and he came to see us in the hospital.
You could almost not discern that he was a human being. His face was so massively swollen and damaged. I mean, it was frightening.
Good job, honey.
There's a complex series of laws that have to deal with when the employer is responsible, when their employees are out driving, and when they're not.
I heard about the Summerall case from John Adams. He called me and said he had this very difficult and challenging case, and would I be willing to join with him to handle the case. And so he told me a little bit about it, a very sympathetic, tragic situation. I said, well, we've got the will, so let's go out and find the way. After we assembled all the king's horses and all the king's men, we appear in the trial court. It says it's a simple commute. You can't get around that. They bought the story of the bully, hook, line, and sinker, and suddenly we were out the door and in the streets. Good news. There's such a thing as an appellate court. You can challenge the trial court's ruling if you believe the trial court is not following the law. So I took off my trial lawyer hat, became an appellate lawyer, and we argued the case as we believed it to be. Wylie Aitken, on behalf of the Summerall family, joined by my associate, Megan Demshki. First of all, I would like to say that this case is anything but simple, anything but a common trip back and forth to work under the so-called going and coming rule. As this court well knows, that the going and coming rule and its exceptions cannot be automatically determined pursuant to the court law. It's not a simple formula. They involve in all kinds of different facts, all kinds of different circumstances, and can happen under so many different ways, which is exactly why the overwhelming public policy in this state and across the board is to provide a jury trial to determine how one interprets the facts and how one interprets the inferences that can be drawn from the facts. The appellate court, the three-member court, unanimously agreed that we were correct and we had a right to take our case in front of a jury.
We created this simple triangle that illustrated that instead of going in the straight route from his home to the job site, he was actually being directed away from the job site into this yard. And I think in the most simple sense, that diagram really illustrated Wylie's theory, and that really became a symbol in this case for the benefit to the employer, that really set this case apart and what the appellate court recognized.
Once we went back to the trial court, and that same judge said, we're going to court and this is the law that you're going to have to follow, then everything became the collapse like a house of cards in favor and on behalf of the Sumrall family.
I just feel blessed that the right people were put in place to help us through this.
I couldn't ask for anything better. And they were holding our hands, you know, the whole time. And yeah, it was great. They invited us in, they treated us like family, they helped us with understanding everything. I can't thank them enough.